The next case is City of Akron versus Ladoris Perkins. Again, each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know, as I'll be keeping track of the time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of children, minors, or victims during your argument. You can refer to them by initials or terms like the child. We've read your briefs and are prepared to proceed when you are.
Thank you, Your Honor. Good morning. Joseph Schell, Summit Legal Defenders, on behalf of the appellant, Mr. Ladoris Perkins. Your Honor, I'll reserve 2 minutes for rebuttal. The court should reverse here because the trial court should have granted a mistrial because the prosecutor's improper remarks here were devastating to Mr. Perkins' self-defense claim, such that a curative instruction could not make this trial fair. So the court should reverse and remand for what constitutes a fair trial this time. There are 3 elements to this to the analysis here for a mistrial is warranted for prosecutorial misconduct when 1, there are improper remarks from the prosecution, 2, those prejudiced, here Mr. Perkins' right to a fair trial, and 3rd, that a curative instruction isn't sufficient to cure the prejudice to cure that prejudice to a fair trial. And we have all 3 here. I plan, of course, can answer questions on all of them. I plan to spend most of my time talking about the 2nd and 3rd elements, as I think the case law, particularly Woolake from the 6th District, makes pretty clear that the trial court striking a prosecutor's remark from the record is good evidence that that was an improper remark. I don't really anticipate that the city will defend exactly what the prosecutor did here, because I do think it's sort of obviously improper to blurt out the prosecutor's take on the contents of evidence that it knows is inadmissible. Now, those comments prejudiced Mr. Perkins' right to a fair trial because this case is all about the witness's credibility, and the prosecutor's remarks infected the jury's determination of those credibility issues throughout the trial. The prosecution opened its opening statement saying that the critical issue here was self-defense. The case then proceeded with no direct evidence of the alleged assault. It's just KV's testimony, who is the victim, her boyfriend's testimony, and then what Mr. Perkins said, which the jury got to see via the body cam footage when the officers talked to him that night. Other than that, though, there is, that's as close to direct evidence as we get. Those were the only eyewitnesses to this case, to the alleged assault. And because of what the prosecution said, that the victim was not armed, was definitively not armed with a knife because of what these call notes say, right? That makes, in the jury's mind, now we've got the prosecutor sort of reverse vouching for its own witness, right?
Correctly. We had an instruction from the judge at this time.
Yes.
Not to give any weight to the statement made by the prosecutor.
Yes.
Did the court also give a jury instruction, and I don't recall if it did or not, on whether statements made by the attorneys are not evidence?
Yes, it did give that general instruction.
That general instruction.
Yes. But also,
why would we think the jury didn't follow those instructions?
Well, because I think the nature of the statement here and the nature of the case really suggests that the presumptions that the jury would follow the instruction or that the instruction would be effective, those are overcome because we've got just like a he said, she said case, just because it comes down to credibility. And just because you look at what the attorneys were arguing, it was all about, not only just about self-defense and not only just about credibility, but about the amount of force that Mr. Perkins used and whether that was reasonable. When you look at what the prosecution argued in closing, this is on pages 292, 293 of the trial transcript, and then also in rebuttal on pages 300 to 302. What it's saying is that if you believe that he acted in self-defense, if you believe he was attacked first, the amount of force he used was, quote, unreasonable and extraordinary. Well, that's not, that decision, that might not be the case, right? The jury could make an opposite decision had the prosecutor not blurted out that the victim wasn't armed with a deadly weapon, wasn't armed with a knife.
Counsel,
that the security guard who made the 911 call was not a witness to the altercation?
I mean, I think it certainly affects, it affects how the jury is assessing the credibility of, or the weight of the state's case, right? I think it speaks to like why this is a credibility case and why that's really the only evidence, right? Is because that evidence, what the jury saw on the body cam, is evidence that supports Mr. Perkins' self-defense claim, right? The security guard said on that body cam, you know, I talked to Mr. Perkins, he's really shook up about what KV, did to him. You can see on the body cam the security guard is offering photos of and a video recording of, you know, of him talking to Mr. Perkins, photos of the
But he wasn't a witness, right, to the altercation?
But he wasn't a witness, and I think the jury is, you know, free to draw an inference from that about like why that person might not have been called as a witness by the prosecution, despite being essentially the first responder to the incident. But right, it speaks to like why the critical evidence is just what the eyewitnesses said, what they supposedly saw. And up until the prosecutor's remarks, what the jury had heard is that when Officer Waterhouse arrived on the scene, he was aware that the victim had a knife. He had reviewed the call notes, they said the victim had a knife, he said I was, quote, aware of it being the knife, when I got to the scene. He also said it was very unusual for the victim to just blurt out unprompted, hey, I don't have a knife, as the officers are coming up to speak to her. Said, yes, people don't usually volunteer that kind of information, or that specific kind of information. So that's the evidence that the jury had about self-defense, right? And Mr. Perkins got the self-defense instruction, even just based on the state's own evidence. And then the question then really, as I think both the prosecution and defense attorneys recognized in closing argument, is about the amount of force that Mr. Perkins used, and whether that was reasonable. And it would have been reasonable. At least the jury could have found, right, that it was reasonable had they believed that the victim was armed with a knife, was armed with a deadly weapon. But the prosecutor took that decision away from the jury and weaponized, Judge Stevenson, these presumptions that you're going to get a curative instruction and that the curative instruction is going to be effective, right? Prosecutor knows at that point, I did not disclose these call notes, suspect there's no way they're coming in, but I need to clear up the record so that I can get my conviction. And so blurts out what the prosecutor thinks the contents of that evidence say. We don't know what the actual contents of those call logs are because they're not in evidence. The city didn't proffer them, which I think also speaks to what they might say because they did proffer other evidence that was excluded, but not these call notes. Right, so at that point, right, the prosecutor blurts out, I'm just trying to get these in to say, no, it's not in there. Again, it being the knife. Knife's not in the call logs. Correcting the officer's testimony. So the jury has that. The prosecution had ignored a request for sidebar before blurting that out, right? And now goes to sidebar and knows, right? The judge is not going to let that in, knows that there's going to be a curative instruction, and knows that this court will presume that that curative instruction is effective. That weaponizes all of these things that are supposed to safeguard the fair trial process and turns them against Mr. Perkins and renders his trial, in this case, unfair.
Did counsel below make those arguments when they argued for mistrial at that point in time? It's been weaponized by the prosecutor. The prosecutor knew this wasn't admissible. We know that there's no way curative instruction is going to be able to be successful in this case.
No, not in those words. No, argued that these things can't come in because we didn't get them. I'm learning about them for the first time because the officer answered some questions on cross. Right, and did move for a mistrial, only agreed to the curative instruction after the mistrial was denied. Right, and I don't think there's a problem with that. That's what any defense attorney would do.
Well, we're back to the last case. By saying you want one thing and not getting it, you have to keep objective. But I appreciate it, I think. Yeah, fair enough. I mean, I think, so no, not in those words, but, that is the thrust of what happened, what happened below, is that there was no chance that this evidence was going to come in. And then again, knowing about those presumptions, I think is what really gets to the third element, why the curative instruction here wasn't good enough. The United States Supreme Court in Bruton, made clear that we've got to,
yes, we can presume that these things work. We can presume that juries follow them. But we presume them to the point that we're not, only to the point that we still recognize the limitations of humans being humans and not being able to forget what you heard. And so when you get a statement that's so inflammatory, that's so prejudicial and so central to the defendant's case, we can't just pretend that the jury would unhear that in the same way that it might unhear a different kind of remark about some other like irrelevant evidence, for instance, that doesn't go so centrally to the defendant's claim. And so when it is such highly inflammatory material, we have to say that the jury can't, or we can say that the jury can't ignore that the presumption that these jury instructions will work, are overcome.
Well, for mistrial too, that's just one of 4 factors, right? One of the 4 factors was the curative instruction given. We're still looking at is the evidence strong and was objections made, those types of things, and that all goes into our equation, not just the instructions.
100%, yes. And that is, and the other evidence, I think, being strong is a difference between this case and Paul, which the city relies on. Really, it's the only case that it affirmatively relies on in its briefing. But there, right, the trial court had before it Mr. Paul's admission that he had committed the crime. There was overwhelming direct evidence in that case. I don't remember the details of exactly what that evidence was, but there was other evidence he had admitted also in evidence that was admissible that he in fact did the crime. We don't have that here. Mr. Perkins on the body cam from the beginning, was saying, I acted in self-defense. She attacked me first. We've got evidence, sufficient evidence to get the self-defense instruction. The question then becomes the reasonability of the force. That's what both parties argued in closing arguments. And there's really no way for the jury to conclude that this was reasonable force given what the prosecutor said. The jury knows now that the call-alongs do not say that she had a knife. There's no other evidence that the victim had a knife. So the reasonability of Mr. Perkins' force has been stripped from the jury at that point. That's the deprivation, that's the prejudice to Mr. Perkins' right to a fair trial, which is the third element.
Mr. Perkins himself, as I recall, he didn't say there was a knife.
He did not say there was a knife.
He didn't say I had acted self-defense because this person had a knife. He claimed a woman with a walker was attacking him or something. So and when I say evidence, he did not testify. We're talking about what was said on the body cam.
That's right.
When I say here do we know what happened from Perkins' perspective,
yes,
it's here that the body cam came in.
Yes.
He never testified, never subject to cross-examination, anything about his testimony.
Correct.
And he's not saying there was any knife. He wasn't presenting a strong self-defense case. It seemed to me on the body cam.
So he did say that he was attacked first. He said, and there were, even Officer Torneau testified that he had what looked like defensive wounds on his face, on his arm. He had been scratched, on his forehead and just below his eye. For the jury to have concluded that he used reasonable force to repel, in self-defense, to repel KV's attack, he wouldn't have to say, she attacked me with a knife. He
got that though. Didn't he get the opportunity to present that, his self-defense?
He got the opportunity, he got the self-defense instruction, right, based on the state's evidence, which included his statements on the body cam. Yes, he did get to present part of the self-defense, defense, right? What was stripped from the jury, though, is the question about whether that force was reasonable, whether it could have been reasonable given that, had the jury been able to find that KV was armed with a knife, or that Mr. Perkins had a reasonable belief that she was.
Now, I seem to recall from the state's brief that they suggest that the use of force was sort of minimal as presented by the defense.
I think there's conflicting statements about that.
Is that not right?
Yes. So I think at one point, yes, Mr. Perkins on body cam says I needed to, I needed to get her off me. I needed to do what I had to do to get out of there. Not really any details about, the level of force. I think defense counsel argued in closing arguments, right, that he pushed her off of, that he pushed her off of him. Mr. Perkins pushed KV off of him. So yeah, I think there's different classifications of like what the force was. But most of those things come from statements of counsel, right? And the jury could have found based on the facts as they knew them in evidence that his force was reasonable if it was reasonable for him to believe that KV had a knife. That's the decision that was stripped from them because of what the prosecutor blurted out. And again, because it's so central to the self-defense claim.
You're down to a minute.
Okay, thank you, Your Honor. Because that's so central to the self-defense claim, that's what makes it so prejudicial, and that's why the curative instruction wasn't good enough. Thank you.
Thank you, Your Honors. Brian Bremer on behalf of the City of Akron. I think primarily in this case, the statement of the prosecutor that was made was not inflammatory. It really wasn't. It was a statement of the made out of frustration in a moment about a dispute involving evidence. It shouldn't have been made, and then there was a curative instruction given. But it has no real effect on the trial. And the reason is that Mr. Perkins takes the position on appeal here that there's no direct evidence. Well, eyewitness testimony about what Mr. Perkins did to me, or what I saw Mr. Perkins did to my girlfriend, is direct evidence. And the jury heard from the victim and her boyfriend about what happened in that room, according to them. Then on the body camera, Mr. Perkins gave a different version of events. He said he got attacked and he pushed her. That is the quote from the body camera. That did what he had to do to get out there was the prosecutor's closing arguments. Like that's the defense attorney's closing arguments. That wasn't what he said on the video. He said he pushed her. If he pushed her, it didn't matter if she had a knife or if she just attacked him first. That would be reasonable force. The fact that that's the issue here, is that whether or not she had a knife is a moot point given the amount of force that Mr. Perkins claims to have used against her. The jury clearly didn't believe that because they saw her injuries. The victim had a giant knot on her head. You can see it on the body-worn camera. And they just didn't believe him. That this woman who uses a walker to get around charged at him, and he couldn't get away unless he did that damage to her. And that's what the evidence is in the record. We have a lot of discussion about these call notes, but as I point out, these call notes are a little bit of a red herring in the sense that the statements in them aren't actually admissible to prove the truth of the matter, or whether she had a knife or not. Because we know from the record that the person who called 911 and therefore spoke to the dispatcher and therefore created those call notes was not a witness to the events. And there's no evidence that this person had any information that had hearsay within the hearsay that would allow this testimony to come in. If the security guard needed to have this evidence brought in, they would need to testify, and then that subsequent evidence would need, how did he come up with the idea that she had a knife? That would have had to come in under a hearsay rule as well. But that didn't happen here. So basically what we're having all this evidence come in about call logs that probably shouldn't have come in, but it did. And then the question is, what is in these call logs? And Mr. Perkins keeps saying, well, the city didn't profit them. Well, no, we didn't. We didn't need to. We weren't using them. They weren't admitted, and that's the end of that. There's a Mr. Perkins wants this court to make assumptions about what's in those call logs, but State versus Roberts from Friday just decided this issue, that you can't look at what could have been in the record or what may have been in the record. It's what is in the record when you look at these issues. And what is in the record here is just the fact that 2 witnesses said that Mr. Perkins attacked the victim. 2 witnesses said that he kicked her and punched her. And Mr. Perkins says, I just pushed her and she scratched me. And if you say that someone scratched you, that's not how you describe someone attacking you with a knife. You say, she cut me. That's just the reality of it.
Remind me, did Mr. Perkins present any evidence?
No, Your Honor. It was all state's evidence.
And yet his evidence came in, if you will, by the body cam, him talking on the body cam.
Yes, I don't know if, I guess I don't want to swear that there was no exhibits presented on cross or something like that, but he did not present. He did not present his own witnesses. He may have had exhibits for cross. Correct. It was all state's case here. And the issue.
Does that at all go to the strength of the evidence on the 4th prong when we're looking at whether the trial should be granted?
Well, I don't think there's any. I think the reality is the evidence from the 3. There's 3 people who were there for the incident: the victim, the boyfriend, and Mr. Perkins. And again, Mr. Perkins told the evidence that Mr. Perkins presented evidence or his version of events presented through the body camera was, I pushed her. That's minimal force. If she's attacking him first at all, that's very clear self-defense.
Was there contradiction between the two witnesses who testified?
There were minor ones about where they were sitting. They were consistent on punching and kicking. Both these individuals who testified, I would describe, like, they seem to be rather infirm in the sense that, like, when they describe the attack, you get the sense that the boyfriend was unable to intervene because he couldn't get up to help her. And I think there's a little bit of just, like, how antagonistic was the victim verbally towards Mr. Perkins, I think differs a little bit between the two individuals. But generally speaking, about the actual attack itself, it's not, the inconsistency of de minimis is how I would describe them. The other thing I just would say too is we say, like, well, we can assume what's in those call logs because the prosecutor didn't introduce the proffer them. Well, you could say the other way, which is, well, they were presented to the defense counsel decided not to let them in. You know, if they mentioned a knife, they would have probably come in. But that's not before the court. Both ways, it's speculative. And the record before this court is just simply what happened, what was the evidence presented. Vicious attack was the victim claim. Vicious attack was the boyfriend claim. I pushed her, is what Mr. Perkins said, after she attacked me. The jury seemed to believe two of those people, not the third one. And I think that that's not a reason to say that there's no reason to believe the curative instruction was just, like, ignored here. The jury wasn't asking more questions about the knife. They weren't asking follow-ups. They weren't doing repeated questioning that makes you say, oh, there's a problem here. They heard the instruction. It was given again at deliberation time, and then they moved, and it was never brought up again. The other issue that I think is worth pointing out is in Bruton, which is the Supreme Court case. That case, the evidence is significantly different than the prosecutor saying there's no mention of a knife in these call logs. In that case, the jury heard the co-defendant's confession. The co-defendant in that trial confessed and that was entered into evidence. And the court said you can't overlook that. Like, that is so problematic because no jury can ignore it. Well, your co-defendant is sitting next to you admitted to this. You clearly did this too. The curative instruction wouldn't operate there. That's different than saying whether or not there's a knife and they mentioned these call logs, which again, they were told to disregard it and then it was never brought up again. And again, and if there was a knife or there was not a knife, the use of force that he claims he used would have been permitted under the facts.
Is there a difference for curative instruction between evidence from the witnesses and statements from the prosecutors?
I'm not aware of any, Your Honor. I think that there's a concern of prosecutors, the prosecutors making claims can be problematic. That's why they're not allowed to testify. But they are not at the same time different curative instructions. The cases where there's a lot of imputation of, like, bad faith here. But again, if you read the transcript, it's pretty clear what happened was it was a statement made out of annoyance about the circumstances. It was not. There's all this idea that, oh, he was intending to, like, get this in before the jury, and then he knew the evidence wasn't going to come in. Well, he had call logs. He gave them to the defense counsel. If there's a mention of the knife, the defense counsel probably was going to let him in. The defense counsel didn't want to let him in. Okay, but you don't know that till you present them to them. They could come in at that point if they. And it's fair that the defense counsel didn't bring them in because, again, they weren't presented at that moment. But there's no reason the prosecution would know they weren't going to be coming in, given there's all this testimony about them. And they could have taken time to talk about them more. They could if they went on to move forward into the trial. So our position is simply that what happened here does not rise to destroying the fairness of that trial. The trial went forward. There was a hiccup. It was objected to. There's a curative instruction. It did not need to have a mistrial given under the circumstances here. If there's no further questions, I'll rest.
You have about 1 minute.
Thank you, Your Honor. One broad point here on rebuttal. The point here is not whether in fact KV had a knife. That's not the point. The point is whether the jury could have believed, is what credibility determinations could the jury have made about the eyewitnesses after the prosecutor's statement, right? As the city's council said, there were only 3 witnesses who saw what happened. All were interested, right? One was the alleged victim, the other was her boyfriend, and the third was the defendant. The only disinterested witness, and the city said, right, how antagonistic the victim was a little contradictory between these 2 witnesses, right? That suggests that maybe the victim is not telling the truth. The only disinterested witness that the jury heard from, really, about self-defense was what Officer Waterhouse said about the call notes, and said that, yeah, I got there and I knew, based on these call notes, that the victim had been armed with a knife. That, whether she had one or not, is not the point. The point is what that does for whether the victim is believable after that statement and after what the prosecutor reported out about the call notes. And after the prosecution's, like I said, sort of reverse vouching for Officer Waterhouse's testimony, what that does is tell the jury, believe what KV was saying and what the defendant, right, and you should, based on what my take of the evidence, right, I think that the victim is telling the truth and the defendant is not. When that kind of statement and pressure comes from the prosecutor, it carries extra weight because of the integrity that law enforcement personnel are supposed to carry into the courtroom and the weight that their statements and testimony have with juries. And that's why this statement in this case was so prejudicial to Mr. Perkins' self-defense claim, and why a curative instruction could not remedy that damage to his right to a fair trial. So the court should reverse. Thank you, Your Honors.
The court will take this matter under advisement and issue a ruling in due course. The clerk of courts will mail you a copy of the decision on the day it's released, and also our opinions are posted on the Ohio Supreme Court website. Thank you both for your presentations.